Hello, I'm Susan Guthrie, America's Divorce Innovation Specialist, and today I'm going to talk about what no fault divorce really means. Because one thing I've found over my 30 years of practice is that many people misunderstand this term and its application to their divorce. So, overall, no fault divorce means that the court's not really going to look at what the reasons for the breakdown of your marriage were. So understand that before states had no fault divorce, you had to actually prove fault on the part of your spouse in order to get a divorce, in order to be allowed to dissolve the marriage, the legal contract of marriage. And you had to prove some pretty extreme things. You had to prove adultery. You had to prove habitual intemperance. You had to prove intolerable cruelty, abandonment for more than 1 year without support, imprisonment for a felony, mental insanity. These were things that in some cases could be very difficult to prove. Some of these things are by their very nature behaviors or things that people hide. Adultery is not something that is usually easily proven. Getting pictures of actually people, this is the whole why private investigators had cameras at the keyhole of the door to get pictures. So in the past, you had people in really horrible marital situations who, because they could not prove these things in a courtroom with evidence, they were stuck in those terrible marriages. So that's why no fault caught hold, and why every state now in the country has some version of a no fault divorce provision. Most states do still have fault grounds, but the vast majority, and by that I mean way over 95% of divorces, are granted these days on the grounds of irretrievable breakdown, meaning the marriage, for whatever reason, and it doesn't really matter that much to the court, has broken down. The breakdown is irretrievable, meaning it can't be remedied, and therefore the marriage will end. That legal status will end. Now, it depends in some states as to whether or not fault will have any bearing on your divorce. So it's not going to have a bearing on whether or not there will be a divorce. And for those of you who are out there saying, well, sure, my spouse wants a divorce, but I don't think it's irretrievable. I think if we go to counseling, we could bring this back. We could reestablish a relationship. Understand, and this is difficult, that if one of you wants it, it's going to happen. You can delay it. You can drag it out. You can do a variety of things that are going to, unfortunately, probably cause conflict and increase the cost. But if one of you wants a divorce, it's going to happen. But there are some states that are equitable distribution states, such as Connecticut, where I practice, where the issue of fault might have some bearing on the actual divorce, on how things play out. So I'm going to speak about Connecticut. I suggest checking with a qualified attorney in the state in which you reside to explore this concept further. But in Connecticut, at least, the court, under the statutes, under the laws around divorce, has the right in its discretion, meaning the judge in his or her discretion has a right to take into consideration the reasons for the breakdown of the marriage. Who was at fault or more at fault than the other for the marital breakdown? And if the court finds that one of the parties is more at fault, the court has the ability, but is not required to, take that into consideration among other factors in awarding alimony and or the distribution of the marital estate, meaning the court can take that into consideration. Now, I want to say that I do want it to be known that judges, you really have to shock a judge with the fault, the reasons, and the basis for the fault allegations before you're going to get a judge usually to take that into consideration and to give it much weight in the alimony determination or the property settlement. But it is a possibility. Um, on the other side of the fence, in a community property state like California, where I'm also licensed, it really doesn't matter. It is no fault. It's no fault all across the board. And the marital community property is going to be divided 50-50. It does not matter who was at fault. It does not matter what bad things people did. And that's just how it's going to happen. And that is not something that the court is going to or has the ability to take into consideration. So the law on that varies by state. And again, check with an attorney in your state. But understand that no fault divorce really means that if one of you has decided that they no longer want to be in the marriage for whatever reason, that divorce can happen, will happen if that person asks for it. So please see my other YouTube videos for more information on divorce, and visit my website, divorceinaBetterWay.com, where I have carefully curated resources for you, other appearances in media and magazine articles for you to educate yourself on various topics. And feel free to reach out to me at Susan in Divorce at Divorce in a Better Way. And I'll see you next week.